The Housing, Community, and Economic Development Committee will now come to order. We'll commence as a minority committee. We do not have a majority present. So with that, staff will read item 1 into the record.
Michael Keck, CLA's office. Item number 1, motion Garcetti Wesson relative to a request to the city attorney to prepare and present an amendment to the foreclosure registry program ordinance within 30 days that deletes the ability for lenders, beneficiaries, or trustees to opt out of the foreclosure registry program registration requirement if they register with the mortgage electronic registration system.
Okay. All right. Is there anybody here from the public who'd like to speak on item number 1? We are on item number 1. I do not see any public comment cards filled out on item number 1. Okay, that being the case, public comment is now closed. So with that, I don't have any questions at this time. So it would be a recommendation of the chair that we adopt the motion. Okay, item number 2.
Item number 2, LHD and CAO to report relative to authorization to execute a First Amendment to the contract with CSG Advisors, Inc. to extend the term by 1 year to January 1st, 2013 to continue CSG services as LHD's financial advisor for its bond program.
Okay, thank you very much. We're on item number 2. Public comment is now open on item number 2. Is anybody here to speak on item number 2? Okay. I don't see any public comment cards filled out on item number 2. So with that, public comment on item number 2 is closed. It'll be a recommendation of the chair that we adopt the LA Housing Department's report. We now move to item number 3.
Item number 3 is scheduled for council May 30th, 2012. Motion Carnes Wesson relative to a request to amend contract number 119163 with the LA Conservation Corp. in an amount not to exceed $1.7 million and for the period of April 1st, 2012 to March 31st, 2013 for the 2012 Gang Reduction and Youth Development Summer Night Lights Program.
Okay. Is there anybody here on item number 3? Public comment is now open on item number 3. I do not have any public comment cards filled out on item number 3, so public comment is closed on item number 3. So with that, it's a recommendation of the chair that we adopt the motion. We now move to item number 4.
Item number 4 is scheduled for continued from May 2nd, 2012. LEHD report and ordinance and CAO report relative to approval of the results of the Tupper Tobias Village Child Care Center request for proposals, selection of Around the Corner Center for school age enrichment, execution of a loan agreement and purchase and sales agreement with the Around the Corner Center of school age enrichment, and approval of an ordinance affecting the sale of Tupper Tobias Village Child Care Center located at 9273 Tobias Avenue in Panorama City.
Okay. Is there anybody here to make public comment on item number 4? Is anybody here on item number 4? I do not have any public comment cards on item number 4. With that, public comment on item number 4 is now closed. So, could I have the CAO answer a question, please? This initial action that put this in motion is quite old. I think this took place in the mid-90s or so.
That's correct. Trina Unziker, Office of the CAO.
And that being the case, are all of the elements intact as far as whatever funds were used, et cetera? Are we okay there?
Yeah. My understanding through housing is that all of the funds for home are intact. And with CDBG, while housing has authority to use these funds, CDD is ultimately the administrator. And so we asked CDD to take a look at this, particularly because the file has aged, and asked them to review whether everything was in compliance. And my understanding is that it is within compliance.
Okay. All right. Thank you. With that, again, public comment on item number 4 is now closed. So it'll be the recommendation of the chair that we adopt the CAO report. Thank you.
Thank you.
We will now hear items 5 and 6 together.
Item number 5, motion Perry Garcetti and CLA report relative to preparation of an oversight ordinance to the for HACLA. Item number 6, motion Alarcon Huizar relative to an instruction to the CLA with the assistance of the city attorney and the CAO to provide the council with a report relative to including HACLA in the purview of section 245 of the city charter and the options and processes needed to effectuate the change, including, if needed, amending the charter, state, or federal legislation, or the cooperative agreement with the city with HACLA.
Okay, thank you. We'll go to public comment first. We only have one card. We are now on items 5 and 6. Public comment is now open on items 5 and 6. We do have one public comment card filled out for item number 5. Michael Millman.
Yes. Good morning, Michael Millman, M-I-L-L-M-A-N, 2100 Sawtell. As a housing provider and as a member of several housing groups associated with AGLA, which we have 11,000 members, AOA 17,000 members, Southern Cities 3,000 members, we strongly believe that the City Council has to take a very, very responsible, tenacious, and aggressive position in overseeing the Housing Authority. We think there should be at least 2 members on any oversight committee as housing providers. The real problem is if you want to put people in Section 8, you need cooperation and participation from apartment owners. You will never get that participation unless they sit on the committee and they can help you form a protocol that makes it a one-stop, easy program to get into the program. Every one of those organizations is opposed to Section 8. They believe now that money is being illegally funneled into special housing programs competing with us in the general market. My suggestion to the chair and others is put a couple of apartment owners on that committee, maybe a vendor, possibly a plumber, electrician, or a gardener. If you want to put people who are eligible into low-income housing and make that Section 8 work, you need to marry up the housing provider and get rid of the bureaucrats, or at least marry them up. We'll do it free of charge. We're not asking to be paid, but I'll make that program work for you, and I'll put 40,000 apartment owners behind that program if you let us sit at the table. Thank you for your time.
Okay, Mr. Millman,
Yes, sir.
is it your understanding that technically and legally that apartment owners cannot be a part of it, or you're just saying that so far it appears that they have not been included?
My understanding is historically and anecdotally, housing providers have never been able to sit at any table anywhere to help.
Well,
on these.
you might want to modify that. You mean housing providers, at-market housing providers, not not-for-profits? Because I think not-for-profits have had a seat at the table.
Yeah, I'm just saying, thank you for your correction, sir.
Okay.
Thank you, sir.
Thank you. Just wanted to clarify. Okay, we now have 2 more cards. Elizabeth, we're on items 5 and 6. Elizabeth Blair, I think, or, I'm sorry. What's that? Blake, you should be a doctor. I can't read your writing. Anna Hernandez, please come forward. Go ahead, Elizabeth.
Good morning. My name is Elizabeth Blaney, and I'm a resident of Boyle Heights, and I work for Unión de Vecinos in the LA Right to Housing Collective. And I'm here today to support the motion from Councilman Alarcon and Huizar regarding the City Council having more oversight over the Housing Authority. I've been working with public housing residents since 1996, and we have seen a lot of issues and problems with the lack of oversight. In 1996, back with the demolition of Pico Aliso and Aliso Village, there was a lot of mismanagement of funds when Don Smith was the executive director and Lucia Lois. She ended up having a lot of problems because of mismanagement of funds. That kind of pattern has continued throughout the last 16, 17 years. I understand that there have been efforts to improve how funds are managed, improve how there's more oversight, but having it be directly going through HUD is not working. And we would support any motion or activity for the City Council to start having oversight over the Housing Authority. As well as, since there is an affordable housing crisis, and the Housing Authority does provide housing for low-income residents, we think there needs to be more connection and coordination between LAHD and HACLA to be able to address that problem and to be working together to solve the housing crisis here in Los Angeles. Thank you.
Thank you. Ana Hernandez. ¿Se conocen?
Voy a traducir.
I gather by the shirts.
Buenos días.
Good morning.
¿Puede juntar el micrófono, por favor?
Sí.
Ok, mejor.
Buenos días a todos los señores concejales.
Good morning to all of the council members.
Mi nombre es Ana Hernández. Yo soy residente de Pico Aliso.
My name is Ana Hernandez, and I'm a resident in Pico Listo Public Housing.
Y también soy una de las cofundadoras de la Unión de Vecinos.
I'm also a founder of Unión de Vecinos.
Y la razón que se fundó esta unión es precisamente porque fuimos un grupo de residentes que la autoridad de vivienda nos notificó que teníamos que dejar nuestros apartamentos.
And one of the reasons we came together is that I'm part of a group of public housing residents who formed because when the Housing Authority wanted to demolish our housing.
Y violando ciertos derechos de los residentes, desde luego que nosotros pensamos que no estaba en lo correcto en cuanto a la notificación del desalojo. Entonces nosotros, grupo de personas que nos reunimos, formamos esta organización.
And one of the other reasons we came together is because at that time there was a lot of violation of our rights as residents, especially around the notification and trying to evict us with respect to the demolition. And so we organized and came together to work together.
Y el motivo de hoy es estar aquí, apoyar la moción para que el concilio tome el poder de controlar todos los la administración económica de housing, porque como ustedes sabrán ha habido tantos malas administración en cuanto a la economía, y entonces nosotros queremos que también los residentes sean partícipes de cómo se puede distribuir este dinero.
Today I'm here to support the motion for the City Council to have more power and control over the Housing Authority and its administration. As you've seen, there has been in the past a lot of the finances that were badly administered, and so I support having more residents participate in this process and that the City Council take this over. Thank you.
Gracias.
Gracias, thank you. Okay. That concludes the public comment cards that have been filled out and passed to me on items 5 and 6. So that concludes public comment on items 5 and 6. Public comment on items 5 and 6 are now closed. We could have the CLA come forward and CAO and the appropriate person from the City Attorney's Office to answer questions, and also obviously the HACLA. Hopefully we have enough chairs. Okay, go ahead.
Good morning, I'm Felipe Chavez with the CLA's office. Before you today is a CLA report in response to various council requests for information relative to providing the City Council with oversight over the Housing Authority. One such request was a 2009 council instruction which directed our office to negotiate an amendment to the cooperation agreement that the city currently has with the Housing Authority. Additionally, a motion introduced by Councilmember Alarcón instructed our office to examine whether the Housing Authority could be included under the purview of City Charter Section 245. And lastly, a motion by Councilwoman Jan Perry instructed our office to provide recommendations that would provide the council with selective oversight of HACLA without the day-to-day operations. In response to these requests, our office met with HACLA representatives, including the city attorney, who advised that any action that would provide the council with authority to approve HACLA items, including the potential inclusion of HACLA under the purview of Charter Section 245, would subject the city to liability. The CLA report contains several options that would provide the council with various levels of oversight, some of which would require additional study relative to budgetary, procedural, policy, and legal implications. However, based on in-person and phone conversations with HACLA officials and research findings, we recommend that the council instruct our office to work with the city attorney to finalize the amendment to the existing cooperation agreement between the city and the Housing Authority and include the following protocol. Number 1, to forward to each council member all posted HACLA agendas. Number 2, remove from HACLA agendas any items requested by council for review. Number 3, upon council request, submit for council review any items scheduled on HACLA agendas. And number 4, be available to present to council and its committees. Our report also includes a section on historical council attempts at improving the management practices of HACLA and a timeline for your consideration.
Okay. Thank you. Also, one of the things that I'd like the city attorney to clarify for us, based on the city attorney's opinion, if the city of Los Angeles were to engage in the activities that have been outlined on both the Perry Garcetti motion, Alarcon Huizar motion, what kind of, would there be any change in the city's responsibility and or liability if we were to do so?
Yes, Councilman. Concern is that since HACLA is a state chartered entity, separate entity, right now the city is not liable for any actions of HACLA. But as soon as we have any direction from council or the city of any matters that, pending before HACLA, that's when we could open up liability. Recently, one example of this would be we have a trash fee lawsuit. The tenants sued HACLA recently. The city was not named in it because the city is a separate entity, had nothing to do with it. But if the city had any kind of oversight over HACLA or directing HACLA of any
Now
kind of action.
There's a difference when, for example, the city of Los Angeles asks another jurisdiction to give us some information or to provide us with some insight or answer some of our questions.
Yes.
Now, so you're using the word in a legal fashion, the word direction,
Yes.
meaning that once the city of Los Angeles, i.e. the policymaking body, the city council, for example, if we were to instruct HACLA and if we were to impose our authority
Yes.
over HACLA, that's where what you're talking about, that kind of triggers, we are now we have a different relationship, correct?
Yes.
It enhances, dramatically enhances our legal responsibilities.
Yes.
Okay, question to HACLA, what is the geographic area that HACLA covers? Is it exactly the outline of the city of Los Angeles, or is it beyond it? What is it?
Doug Guthrie, the CEO of HACLA. The primary responsibility for HACLA just covers the jurisdiction of the city of Los Angeles. We do also have a separate not-for-profit arm, the LA LOMOD program, that administers, under HUD's direction, Section 8 contracts that cover a good portion of Southern California.
Okay. So there's a big portion of your primary responsibilities are the same as the geographic outline of the city of Los Angeles.
That's correct.
Same exact constituents.
Yes.
However, you do have other responsibilities beyond that.
Yes, that's correct.
Okay. City Attorney, so can you give us an example of the city of LA, an example of how we could legally enhance our authority with HACLA, and then secondly, an example of a liability that would come out of that? Not that we would get sued as a result, but we would, for example, that a liability that would result that if somebody did want to sue HACLA, they would name the city. Get what I'm saying?
Not too clear.
I mean, looking at both of these motions, for example, one of them talks about the authority or ability to use our Section 245 of the city charter. Also, some of the recommendations from the CLA are that that perhaps HACLA could post their agenda, and then as a result of posting their agenda, the city of LA / the council or a council member can call that item off of the agenda until they report to the city of LA, for example. Take your time.
Okay. Well, I think maybe the best way to answer that question is for the CLA's report, they're offering two options, and these are the two options that are available for the council or the city. The first one is negotiate the council's ability to review HACLA matters. That's, I think, what's proposed here. It's a system where HACLA posts their agenda a week before the meeting.
That's a requirement or a custom and practice of theirs?
It's really a custom and practice. I believe we're required to post it within 72 hours, but we, out of practice, we do it one full week before the board.
Basically, it appears that the CLA recommendation is following the custom and practice within the purview of the custom and practice that HACLA's been exercising, correct?
Correct.
Okay, go ahead.
Yes. And so, because after HACLA posts, I guess what the procedure that's proposed is after HACLA posts the agendas, that'll be a week before. Upon posting, HACLA will also send out a copy of the agendas to all the council, CLA, all the city family. And during that 1 week period, the city would have time to review the agenda, and if they had any concerns of any item, they could contact HACLA. From there, HACLA, they can make the request to the Board of Commissioners at the meeting to continue the matter so it could be under review by the city.
Now, the fact that it's a request and not a requirement or a demand, enforceable demand, do you think that would trigger some liability on the city? Because it is a request. Anybody can request that they pull an item, right?
That's correct.
I don't think that would trigger.
Okay, that would not.
No.
Now, what in the recommendations would get into the
Mr. Chair?
area?
I don't read the CLA's instruction to be a request. It specifically says the item would be pulled if a council member requested.
Oh, yes, and that's what we discussed before, that we do need a little change in the recommendation. It's the recommendation 1, 2. And
Okay,
that's-
but hold on,
Right.
slow down. Councilmember Alarcon's correct. First, what I would like to do is look at what it is the recommendations have and if there's any liability concerns in those recommendations as written. Now, if you want to make recommendations to us about what changes we may want to make, should that be a concern that the council would like to adhere to, then let's go through it that way.
Okay. Well, the procedure, I guess, that was discussed was where a request will be made to the board to continue the matter. I think the recommendation here does mention remove from the HACLA agendas.
In other words, upon request of a particular council member, one or more council members, that HACLA would follow through and receive it as an instruction, not necessarily as a request.
Yes.
Okay. So if we were to go down that road, are you saying that the city attorney's office recommends that we continue, if we go down that road, for liability purposes, or the potential of liability, that we allow ourselves, or that HACLA and I and the city have a relationship of requesting that, not either making some demand or requirement?
Yeah. Merely a request.
Okay. Now, you mentioned earlier that as of right now, there does not appear to be any direct liability that the city has based on HACLA's actions.
Yes.
Obviously, there, by and large, are constituents. That's one thing, but that does not mean that we have liability on their actions.
Yes.
Okay. So that being the case, so basically, if liability is an issue that we'd like to be mindful of and make sure that we don't cross that line, then we're talking about some kind of MOU or cooperative agreement, what do we call that between HACLA and the City of LA?
Well, it's merely amending the cooperation agreement between, there's a cooperation agreement that exists with HACLA, yes. And it's merely amending that to reflect this procedure.
Okay, all right. Now, question to you, Doug. Of the recommendations that you see with the CLA, what things do you think that HACLA could actually live with, and based on those recommendations, and the things that would actually cause perhaps a legal problem with HACLA based on those recommendations?
Well, I welcome the opportunity to have much more open, regular relationships with City Council. It's good to be back in front of the committee and working with members of City Council in my new role. And as you may recall, Mr. Chairman, shortly after I was appointed as interim back in mid-December, you and I sat down and we talked about the need to have better working relationships between HACLA and City Council. And what we talked about at the time was one of the easy things we could do is to agree to come before this committee on a regular basis with a reporting format in whatever form that members of council may want to see, so that we can keep council fully informed of the operations of HACLA and be available to answer any questions that may be there. In addition, we talked about my availability and accessibility upon request, both by committee as well as full City Council. I think it behooves us at HACLA to have a far better working relationship with City Council than was evidenced to me in the previous administration. So I think one of the first things we can do, as outlined here in number 1 of the report, is to make sure that members of City Council have full access to all matters that are being considered by the Board of Commissioners, and proactively do that, providing you with the agenda ahead of time, so that if there are any matters that do surface that give you concern or give you questions, that you would have the ability to request to the board to table that matter or to defer it, and we could make sure that that the board is asked that question even at every board meeting, would be a good way to go about it. And again, secondarily to that, come before this committee on a regular basis with a reporting format that you would want to see. That would be the approach that I would like to see us take, as opposed to having the City Council really be in a position to make formal decisions, which again puts us into that whole area of concern over liability.
Did you want to comment? Okay, no. I have another question, then I'll turn it over to Councilmember Alarcon. So if we were to decide to push further, crossing that line of requesting information, requesting that items be pulled, et cetera, and go to instruct or demand, then what documents or what changes would have to be made beyond just a cooperative agreement? Would we have to change the charter? Would we have to change the charter? Would we have to go to state legislation? What would have to take place?
Well, that's the second proposal that's listed here, where council will pretty much take over HACLA. Council would be the board of HACLA. They would replace the Board of Commissioners. And back in the mid-'80s, that's what occurred. And that's what's reflected in the report, the history of what occurred back at HACLA in the mid-'80s. It's something, that's when liability would be imposed, because now HACLA would have the city would have direct influence over HACLA. It's similar to the situation with the CRA, too. And I think, that's an option, but it's something that, the city could consider, but also recall that the situation with the CRA, what happened with the CRA, I know back in the mid-'80s, council also decided to put the system back in place, where HACLA was a separate entity later on.
And my last question, then I'll turn it over to Councilmember Alarcon. Doug, what is the annual scope of dollars that HACLA is responsible for or oversees, et cetera?
Well, HACLA's core programs include ownership and management of public housing units, of which we have nearly 10,000 units of public housing and other housing assets that we own. We also administer the second largest Section 8 program in the United States, and we have approximately 52,000 units under the Section 8 program. So we administer programs to nearly 200,000 residents of the city of Los Angeles. The total revenue that we work with on an annual basis is approximately $1 billion.
1 billion.
$1 billion.
Good, Richard. And then.
First of all, I want to thank.
I want Richard first, and then I'll go to
yeah,
you.
never mind.
I'm just going in the order that
That's
was
fine.
on
Don't
the
worry about it.
agenda.
Yeah, what liabilities does the city have now with regard to HACLA?
No liability.
No liability?
As in legal, correct? Obviously,
Legal.
Right.
there's a relationship.
Right, there's a relationship.
Who provides police service to HACLA?
LAPD does.
Did they always provide police service?
No, but under agreement.
When they had their own housing authority police, who was liable for policing HACLA?
That was, HACLA was.
So the city chose to accept the liability with regard to policing HACLA.
Well, the premises.
So it would not be precedent-setting for us to assert this level of control, given that we've accepted far greater liability by having the police department inserted into the process.
No,
No what?
it wouldn't be a precedent.
Wouldn't be a precedent, but,
Yeah.
so, the bottom line is that there have been ongoing occasions of disharmony between the city of Los Angeles and HACLA in the 80s, in the 90s, and again in the 10s. And as we move forward toward the 20s, I think we need to tighten that relationship. And the CLA's recommendation that is based on a motion by Ms. Perry, I think, tightens that relationship to allow us to review specific actions that we are concerned with. And most recent history, and this is no slight on Mr. Guthrie, he's a nice man, has great hair, and you know, I like him. It's no slight on him. I think he's a well-intentioned person, but we're talking about relationships between two government entities that have struggled over the years. So in this administration, moving forward, we might be very, everything may be well and good for the next couple of years. But given that there is a major transition in terms of policy that is going on at the federal level with regard to HACLA, and there's a struggle going on, I think there's going to be increasing challenges for the city to retain that relationship in the manner in which it's operating now. The fact we have a cooperation agreement. What is that agreement? What's in it?
It's just merely really an agreement that the two parties will work together. I mean, it's an old agreement, right? And it was established back in the 80s.
Back in the 80s.
So what does it say?
There's no, I mean.
We'll work together. We could,
It
I
really
mean,
established, I believe, the pilot funds.
do we have a cooperation agreement with the sheriff's department, or?
I'm not aware. I'm not sure on that. But
So what?
this cooperation.
You're talking about liability, and yet you say we have an agreement in place. It seems to me we've asserted some level of liability.
Well, the agreement was really to establish the payment of, they call pilot funds, payment in lieu of taxes. And so that's why it's the annual payment that HACLA would owe the city for city services.
I'm not a lawyer. You're the lawyer. But it seems to me anytime there's a contract, and a cooperation agreement would be a form of a contract, right?
Yes.
Anytime there's some kind of contract, both parties assume some kind of liability.
But you're only assuming the liability within the bounds of that contract.
I'm just saying that both parties assume a level of liability. You just told me, when I asked the question, does the city have any liability with regard to Hackla, you said no. How can we have a cooperation agreement without assuming some level of liability?
But that's
Can you
only-
clarify for the councilman what you mean by liability? You're talking, I think that you're speaking at two levels of liability. One, you gave a perfect example where Hakla got sued, the city of Los Angeles was not named. A lawyer does not leave out an entity as big as the city of Los Angeles unless they don't think that they have legal liability, correct? Correct. So could you clarify for the councilman what you mean by liability and legal liability? Because those are two different levels, correct?
Yes.
Okay.
Well, and Hackla has not only the cooperation agreement, they enter other contractual agreements with the city. There are other, right, for different programs.
Right. We have we have different programs with LAPD under the Community Safety Partnership Program as an example. We were talking about pilot, which we bring and that's payment in lieu of taxes. And we bring a budget for that and a proposal back to City Council, which was heard before the Budget and Finance Committee and is to be approved by City Council for how those city funds are going to be spent that would serve the residents of public housing. But there isn't an overall agreement that I'm aware of that for a decision-making process that cuts across all of the day-to-day activities of housing.
I didn't limit it to decision-making. I said, does the city have any level of liability? It's an open-ended question. It's a general, broad question, and
They would
you
only
said
have
no.
liability pursuant to any contracts with Hackla.
Okay, so do we have a contract with Hackla with regard to police service we render?
Well, first of all, LAPD has long served, residents of public housing like they serve residents.
Come on, you had a police department in the 90s that blew up, and we went into
Right.
save your butts.
Right,
My question is there an agreement with LAPD?
No.
Police service?
There is
No.
no agreement.
Well, there's a community safety partnership program. There's a cooperative agreement we entered into, and we're paying for that program on behalf
Exactly.
of LAPD services that began last fall. In terms of us having our own police force, we don't have our own police force.
You used to.
Housing authorities around
You
the
used
country.
to, but it was dismantled because of abuse. Is that not correct?
Well, it was before my time, but I know that historically around the country, New York City, Chicago,
I'm
Philadelphia.
just talking about LA.
Yes, a number of those cities formed their own police forces, and most of those have been disbanded, to the best of my knowledge.
The one in LA was disbanded because of serious, serious problems.
I couldn't
Just
tell you
answer
the history of
probably.
that. I'll take
Just
your
say
word for
probably
it.
so we
Trust
can
the
move on.
councilman who was
I'm sure you're
serving
correct.
in office during the 90s when this all happened. So I think this notion that instructing the board to hold a matter. The one thing I would make clear, I believe that we should tighten the CLA's recommendation to have a specific time period so that a council member can't just hold an item every time forever. That we say that they can hold it up to 30 days or something, and if the council fails to act on that item, then Hackla can move forward with it. But outside of that, I think if we want to build cooperation and trust, which has been the problem of the last year, where we had the general manager of Hackla just ignore us, refuse to come to council, and then go to the press and say that he was afraid to come to council, as if we were going to set the Occupy LA folks on him or something. I don't know what that was about. But the point is, this is a minimal level of cooperation. The 245, which the legislature could enact, if is more. I understand the issues of liability. But the city has in the past taken on liability where we felt it was necessary to maintain the project. I mean, that's not unusual. We did it with the police department. And there's very serious liabilities involved given the high level of crime and the concentration of issues that arise out of the projects that Hackla runs. And the city has willingly taken on those those liabilities. I doubt that the level of liability for asking the board to hold a matter for a small period of time would rise anywhere near the level of liability that we assume relative to providing police service. Otherwise, if your argument followed, then we should just take our police out of HACLA and let them run their own law enforcement like they used to. So I think that the Jan Perry motion and the CLA's recommendation is reasonable, except I would add a friendly amendment to give a time period of say 30 days that the item must be considered by the council. We have that with when we take over actions of DWP or something. There's a time period where I think we have to act. Is there not?
Yes, there is.
There is. So I think that would be reasonable.
Yeah, but we don't have authority to pull something off their agenda, or we don't request that they pull something off their agenda. If we do, it's a completely informal council member to council member.
Well, given the recent history, it concerns me that the same kind of disruption could occur. Where let's put this in perspective. Residents were arrested, were threatened with lawsuits. In fact, I believe there was a lawsuit involved. I don't remember, but they were, in my estimation, harassed for their expression of protest. These are very serious claims, and Mr. Guthrie, none of that happened under your watch. I recognize that. I don't know who's going to be around the next time. I don't know what the circumstances are going to be next time. I know that the residents are organized, and they express themselves. So there's a potential that there could be conflict in the future. And I think since we are appointing the board members, since we're providing the police service, since these are in the middle of our districts, the projects in particular, that we should have a little more opportunity to weigh in at HACLA in a substantive way.
And I believe that the recommendations that we're proposing, as opposed to the specifics of the CLA report, really provide for that. It memorializes the fact that we want to come before City Council on a regular basis. We want to be held accountable for the actions that we're taking. We welcome an opportunity for City Council to be fully informed of the matters that are coming before the board, and we respect the opinions of City Council, and that we open ourselves to come before the committee or full City Council upon your request.
I trust you, but that's exactly what the last guy said when he ignored us. When he came before us and testified, he said he wanted to have an open relationship with us. And then he completely ignored us.
Well, I believe this would take it a step forward as a procedure that would automatically bring us before the council on a regular basis, a reporting format of your request. We would be held accountable for having those open communications, regardless of who
I do support the
would be in
CLA's
leadership.
recommendation. I think the recommendations by HACLA are weak in terms of defining in terms of the effort to build more cooperation between the City of Los Angeles and HACLA. I think they are intended to block the city from having significant input into its actions, and I strongly support Councilmember Perry's motion, and with regard to my motion, I'm willing to forego that until there are more problems. If there are more problems emerge, then if the council chooses to desire a 245, then I would champion that the legislature change the law. But I think this is a reasonable recommendation given the recent history that we've had, and it would be my intent to vote for the CLA's recommendation with the one friendly amendment that we put a time limit on it.
And Richard, you're talking about that be that, for example, items be required to be pulled from the agenda at the request of a council member rather than ask that they do so? So basically, you're saying that based on the city attorney's explanation that actually incurs legal liability on the requirement versus request?
I don't concur with that, but I
I thought you said you were not a lawyer.
I'm not, but I don't have to agree with my lawyer.
Ask the lawyer.
And I don't always agree with my lawyer, but the question, I thought you'd like that, no. But the question, when you say they're going to request, then it goes to the board, they have to take action on the request, and
No.
I mean, that's a convoluted mess.
No.
What happens?
When the agenda is set, correct me if I'm wrong, Mr. Guthrie, when the agenda is set for the HACLA board, custom and practice 5 days before the actual meeting, who has the authority to pull that? Do you have to get the board to take action to pull an item, or can it be done administratively and noticed?
Well, once it's been published, I believe it's a requirement, and correct me if I'm wrong, Craig, it's a requirement of the board to pull the item off of that board agenda. And again, we post it 7 days ahead of time, so.
7 days.
Yeah.
Calendar day.
Until they take action on it.
Well, again, there's plenty of time for any member of city council to voice their objection to any particular matter, to come either before the board to plead the case,
Yeah,
make a request of me, so I can plead the case.
That's
See the point.
always
Yes.
the case.
That's
But
exactly
that's
what
the point.
we should avoid. The council should have the opportunity to consider it in city council.
So you're saying the council should be setting the actual agenda for the board?
No, I'm saying that if we ask to pull an item for a period of 30 days to review it by the council, we have a debate in city council. It's not where a council member has to go to the board and request that. It may be something that we challenge HACLA on.
So what you're describing would be a requirement. In other words, even though it appeared on the agenda, it would, like, if that were to take place,
Right.
it would be announced at the agenda that item 3 has been pulled from the agenda due to the requirement that we pull items if they're requested by a city council member of Los Angeles,
Right.
that they be pulled, right? It would be an announcement, not that a member of the board would say, I agree that we should pull item 3, correct?
Yes.
So
correct.
basically, Councilmember Alarcon is making it clear that he's talking about requirements of HACLA based on the recommendations of the CLA.
And there could be problems with particular matters in that regard. Budget's a good example where we are required by HUD. You have to understand our relationship with HUD is far different at HACLA than it is with the standard HUD programs administered by the city, where there's far more flexibility. This is a pretty regimented program, and we need to do things in accordance with the HUD directive. The budget is a good example. It is required to be approved by a fixed time, and if there's any delay in that, we run into some pretty significant problems. So I mean, there are at least some certain items that would give rise to some concern.
Yeah, it would have to be, basically, the document is getting thicker and thicker should we move forward with requirements of HACLA, because then we would have to outline, notwithstanding if there's a deadline, the federal funds jeopardizing, et cetera, then that would be handled differently upon the requirement of a city council member to pull it from the agenda due to the fact that there's inadvertent consequences that not legal liability per se, but liability of losing those funds or not complying with the grant or whatever it is that you're required to comply with, correct?
Yes, that's correct.
Ms. Berry?
Thank you, Mr. Chair, and thank you to the CLA's office for getting us to this day. And I know there was a lot of back and forth between my office and HACLA and the city attorney, so thank you for all hanging in there with each other and working this out. And also to Mr. Guthrie, since you've been at HACLA, I think we've been having a very productive dialogue about oversight. Now, I first expressed concern, this is before you got here, Mr. Guthrie, back in 2009, prior to your being here, that HACLA was applying for the same neighborhood stabilization program grant as the Los Angeles Housing Department, And essentially, the city was competing against itself. That was a different time, different leadership, and it wasn't very wise. So after that point, I know that many of my colleagues also expressed concerns about HACLA's travel policy and the retirement package for the former ED and other perks that really didn't line up with the core mission of HACLA. Now, those items concern me, and I'm pleased with your leadership from the standpoint that the Board of Commissioners has adopted a new, stricter policy regarding travel, vehicles, and purchasing cards. And I think moving forward, the CLA's recommendations make sense because they represent a thorough vetting from all of the stakeholders. An amendment to the cooperation agreement, I think, will afford the council the ability to be better informed about HACLA's plans through a systematic approach of information distribution and a time period to provide input. I think this approach gives us the ability to move forward without having to delay or to wait for state legislation, and it does not present any new potential liability for the city. I think the CLA, the city attorney, should be able to work together to prepare the amendment to the cooperation agreement, and I had said 30 days, but if somebody wants to make it less time, that's even better, because we can begin to more aggressively engage in HACLA matters sooner. This agency is so important to moving forward in housing people. We have a portfolio, or HACLA has a portfolio of over 6,500 housing units throughout 16 housing projects. HACLA administers monthly housing assistance to more than 100,000 residents. It also administers a Shelter Plus Care program and the Section 8 program and the Veterans Affairs Supportive Housing Program, or VASH. So it's a critical partner to develop, retain, and preserve affordable housing. So I hope that we'll be able to adopt the recommendations of the CLA today with a friendly amendment, which I am supportive of, and move forward. Council.
So also, Ms. Perry, you would want to go with the stronger language of requiring HACLA, not asking HACLA?
Yeah, that's fine.
Okay. All right. It seems to be the same opinion of Councilmember Alarcón.
Ms. Perry, there may be urgent situations that require timely consideration, and maybe the CLA and the city attorney can work on those, providing some out where we don't put you in jeopardy with issues like budget and federal mandates. And so maybe when we, if this goes forward to council,
Yeah.
we could work on tightening those up a little bit.
So, okay. We have basically two different kinds of sets of recommendations from the CLA, if I'm not mistaken.
There are two recommendations, and recommendation number one includes the protocol, which has, it should be 1, 2, 3, and 4 protocols. And I asked the city clerk to make a technical correction to that, and it should be 1, 2, 3, and 4.
Okay. So what we have before us is a motion to approve the CLA's recommendations with the amendment by Alarcón.
It's my motion, so I guess,
Okay.
how do you want to do that? You just want to vote on it?
Yeah, we'll go ahead and vote on that.
Mr. Chairman, if I could just make one more comment,
Sure.
please, before the vote. I think it would be my understanding that any sort of amendment to the cooperation agreement would need to go back to our Board of Commissioners. Is that correct, for approval by the board as well? So whatever actions are taken by City Council
Sure.
would also need to be entertained by
And that would be
by the board.
subsequent to city council actions.
Yes.
Okay, all right, got that. Okay, so with that, the CLA's recommendations as amended by Councilmember Alarcón is before us. All those in favor? All those opposed? I'm opposed. Okay, so that's a 2-to-1 vote. So it goes as a minority report to the council, or?
Yeah, if you don't have a majority of the committee present, then there's no action. The committee might as well sign the report that way, and then it will have to be taken up by motion in council.
Okay, and council will clarify which one they want to take up. Okay.
Pardon me, Mr. Chair, I need clarification on, again, on what we're voting on. We are voting on the the recommendations for the CLA with the technical correction, and then with the friendly amendment by Councilmember Alarcon to change the language from request to require, and then also to add a time limit of 30 days. I'm sorry.
I thought it already required it. The language already requires it. So the friendly amendment was to put a time frame of 30 days where the city council must consider the matter, or Hackler could move forward.
In other words, silence means they can move forward after the 30 days expires.
The pulling the item was part of the CLA's recommendation.
Okay, so the friendly amendment is the 30-day time limit.
Correct.
And
to act, or Hackler can move forward.
okay, and in terms of the voting, I'm trying to clarify. There was a discussion of a minority report.
No. It was clarified that it'll go forward since there was no majority vote on the item.
You sent it forward to council with no recommendation?
Yeah, with no recommendation.
There is no recommendation.
Yeah.
Council Rule 69.
What's that?
It would be following Council Rule 69.
Yeah, the council will decide. Somebody will have to make the motion as to what they're going to vote on in council. And then also, aside from that, there was an instruction to the city attorney and the rest of the parties to go ahead and work on explaining some of the timelines of I don't know, specialty items or deadlines or what have you, and how those would be handled. Okay, so you'll work on recommendations on how those could be handled. Okay, that was an instruction. Okay, anything else on items 5 and 6? Okay, all right, that concludes the items as scheduled on our agenda. We have,
Mr. Chair, would you want to ask the other council members if they want to join you in approving items 1 through 4, since they were taken up before we had a quorum?
before we go to general public comment, we went through items 1 through 4. Would the 2 other members like to concur on those actions?
And Council would just clarify, for item number 2, a CAO report hasn't been received yet, so you would just be approving the LHD report.
Okay, LA Housing report on item 2. Okay, that being the case, okay, we have 3 members concurring on items 1 through 4. Okay, thank you. We have general public comment, Michael Millman and Noel Weiss.
Good morning again. Michael Millman, M-I-L-L-M-A-N. I'm a housing provider, 2100 Sawtelle, Suite 105, West Los Angeles. I want to thank and commend this committee on its outstanding and extraordinary leadership. Within the next few months, as you're well aware, housing providers are required to install, it's mandatory from the state legislature, carbon monoxide detectors. They're expensive. Those devices cost about $50 per unit, and they also cost about $50 to install. And I know members on this committee are very excited to protect the interests of tenants, knowing full well the carbon monoxide units will protect their safety and well-being. However, we have not yet received the kind of leadership we need from our very good friends at the Housing Department as to how to allocate passing the cost through to the people who will benefit. Those are the tenants. There are combo units that involve both smoke detectors as well as the carbon monoxide. Historically, the Housing Department has allowed housing providers to pass through that cost on a prorated basis. We're suggesting $100 at $10 per month to be prorated and added to the rent We think it's appropriate. Remember, it's state mandated, and I want to thank this committee for its leadership in this area.
Thank you. Mr. Chairman, and maybe it could be a joint situation, tenants and landlords, but that's not why I'm here. I'm here to actually address the chairman and the committee, again, maybe in your capacity as one of the Lincoln Place Five, way back when you stood with the tenants. There's a situation under the RSO, yeah, you remember that. It wasn't too long ago. We have a situation where, and I'm on the front lines once in a while here, when these when your rent control laws basically are before the courts. And in the Valley in particular, in this situation, there was a gentleman with AIDS who basically got evicted because he was occupying what amounts to a single room in a R1 house. This apparently is going on because of the economy. Problem is, the RSO law says that in effect is a boarding house, and that tenant has a right to the protection of the RSO, which includes relocation fees. The problem is that it's an R1 zone, and what the judge did in this case, and I'm going to get it reversed, but I think the city council needs to clarify, there was the certificate of occupancy for the R1 was issued in '84, post-dating the RSO, and there's a blanket exemption that says any property owner that has a certificate of occupancy for that post-dates the RSO is, which is 78, basically that they're exempt. So the judge relied on that exemption, but the problem was the certificate of occupancy was issued for an R1 use. This is not an R1 use. You're having unrelated individuals occupying single rooms in a house. It's not really, it's not right. And it contravenes the policy that I think the council set up with rent control. And what I want to do is work with the committee and get somebody, since Janice Hahn isn't here anymore, get somebody to basically stand up for the people and clarify that the council's intent is not to promote speculation and have people being taken advantage of in the situation, but to reinforce what the council intended when it passed the RSO, and you can't use, in effect, have a boarding house in an R2 area. Anyway, thank you. I appreciate your consideration. Thank you.
Okay. Those are the general public comment cards that came before this committee. Seeing no more general public comment cards, general public comment is closed. This committee is now adjourned.